7/20, we're going to just take his withdrawal.
Okay.
Okay, thank you for coming. I think he's going to be appearing before the selectmen, and I hope you'll participate in those hearings.
Do we want to let her say anything, or he's withdrawing, so it doesn't matter?
He's withdrawing, so it doesn't matter. Yeah, and we were appreciative. It went into the minutes. Thank you.
Thank you.
Okay.
She was for it.
I just thought I'd let you go home. It's cold.
Yeah, but I always want to give people a chance to speak if they came all the way down.
That's one of the few houses in town like that.
Quite old, 1867.
So the administrative matters, we are 2 meetings, or 2 months behind on minutes. I see that we have a July set and an August set. If you recall last meeting, I had asked for time because in the July set, Ms. Ellinger chaired 2 of the hearings that were in that set, so I wanted her to have a chance to look at it. And Shelley's not here tonight, so I'm just going to briefly go over what my comments are, make sure you're all in agreement, ask anyone else for their comments. And if you don't have a set, Rod, right beside you, or a couple extra copies, can we pass out July to anyone who doesn't have the set so they can follow along? I think it's that easy.
Okay.
Here's July, here's a July set.
We're looking at July 1st?
The meeting is of July 20th,
Can you switch over,
2017.
Don?
I don't think that makes a difference. I don't think I was at
Do you have
that.
another meeting?
There's a July 20th, 2000, but I need my set, I need my set back, but I
So
don't
they
need
have
because
one?
it's got the red line.
Here's some more.
We have one more, here's another one,
Okay, good.
July 20th.
Are you okay, are you two okay? Are you two okay, Sherry?
Absolutely.
All right.
So, going along on page 1, looked okay to me. I didn't see anything sort of different or something that needed correcting on the Kenny hearing, even though I wasn't there. Even though I didn't chair it, Cheryl, it looked pretty straightforward to me. And then,
Yeah, there was no real problems with that.
going on to Wildflower Meadows, there were a lot of things in here. I just wanted to correct some language, but at 7:45 PM, if you recall, this is the discussion on Wildflower Meadows, when we had a lot of the owner occupants in the room, and they were asking for certain things relative to whether they could add fences, whether they could improve the interior, whether they had rules and regulations concerning garbage and everything. So I've got just some grammatical corrections, lawn ornaments and garbage barrels, not garage barrels, leaving them outside. And then just some language changes in Mr. Gallagher, the next paragraph starting with Mr. Gallagher. Pretty much language changes just to put in periods and punctuation to make it read a little easier. So I'm not changing anything substantive. I think condo association in that paragraph ought to be capitalized, C, capital A for condo association. And when she says some of these things are governed under the condo association, some under the comprehensive permit, she says under the decision. I want to change that to comprehensive permit in that paragraph. And a restriction on the bedrooms, I might want to say restriction on bedroom count in the last sentence. And then on to the next page. Again, just some transition punctuation and, and, ors, and capital letters, just to make it read a little smoother. On the David Hale, starting with the David Hale, I just want to identify David Hale as the owner of the 15 Great Road 40B rental units abutting the project, so there's context about what he's got to do with anything as an abutter.
Shouldn't we put in that he was the original permanent of the project?
Yeah, I mean, to the
Because he's
extent it's relevant.
responsible for
Yeah.
the landscaping
Yeah.
along the road, et cetera?
Yeah, fine, I'll put that in. That's a good
Please.
idea, yeah. And then, Mr. Hale stated as representative of Village Green and the investors, they want to ensure that the items are completed. And then I added, before the town signs off on the completion of the last unit. And then again, next paragraph, it says next sentence, Attorney Alex Para. I just want to put in context that he's the attorney for David Hale. And then go on further against just some language improvements. And then I want to take out on the paragraph beginning Chair Gould at the end, it says, the board needs council input. Mr. Yates asked about bonds. They are generally for infrastructure, not individual lots. I just want to end it there and not say the situation is disingenuous. I don't understand what that adds or detracts from this, okay? And then down to Mr. Sawyer, I just put on a separate matter, Mr. Sawyer asked about water metering and not being able to use the water. And that really had nothing to do with the board's decision, but that came up, if you recall, because they were told they couldn't water their plants. And so we agreed, so I'm adding to that sentence on the next page. The board agreed to inquire as it didn't seem logical to prevent water usage at that project without a good reason. And I think after we did inquire, it turned out it was just seasonal, and everyone was asked not to water that season because we were having a drought.
Now, at that point,
Yep.
we had quite a discussion on the fact that the original plan had a fence along the road and that the neighbors, it was my intention to hold Mr. Hale's feet to the fire to have him build that fence, but that the neighbors, with a show of hands, said they didn't want it, so.
That's the August meeting, and it comes up very clearly in the August
Okay.
meeting, okay? So it didn't come up in July.
All right,
And then,
I didn't watch the minutes for these.
Kimball Farm Village on the Common was yours, and I just thought.
I have one change in the
Yeah,
third
go ahead.
paragraph.
Yeah,
It says the board would like a letter sent to Attorney Counsel, and it was the board requested a letter be sent to Attorney Counsel.
requested a letter.
That a letter be sent to Attorney Ansel, asking if any piping for the wastewater treatment facility extends to the Kimball property. It shouldn't say Kimball property, because it needs to say extends to the Littleton
40B, or Village on
Farm, Kimball Farm
the.
Village on the Common.
Property, okay.
Extends to
fine,
Kimball Farm Village on the Common.
Fine. Okay, so I will ask for a motion to approve those minutes as amended, if everyone agrees. We have, wait a second, I gotta pick voting alternates, right? 1, 2, 3, 4. Katie, you want to be the voting alternate?
Sure.
So who wants to make the motion?
Move to accept the minutes.
All those,
With, as amended.
all those in favor?
All right.
Okay. The second matter on the agenda tonight was a 7:20 posting, and that matter was the 40B, that matter was the, I'm sorry. I know Perkins wrote a letter asking for it. Where did it go? Oh, is it just by an email, or is there a letter on this? So let me open that hearing, because he's here and he can just ask for it. 7:20 PM. I'm opening the continued hearing of case number 890A, 1115 Taylor Street. The petitioner, Nathan Skinner, trustee for Diane C. Skinner Trust, requests for a variance pursuant to section 17326 use regulations for a proposed conversion from an existing two-family house into 4 rental units. Mr. Ansel?
Good evening. I represent the trust. We're asking to withdraw that application without prejudice. We are exploring various opportunities for building that. We understand that there isn't really an opportunity to get a variance for 4 units. We're going to be exploring a local initiative program, keeping the structure from the outside primarily the same, and looking to build 4 units. I'm told that I met with my client today for the first time, and we'll be circling back to the Board of Selectmen and to this board, hopefully with a LIP application.
For what application?
Local initiative program. It'll be a small 40B.
Oh, okay.
The existing 4 units, we're going to be exploring whether or not it would be economically viable to do a 4-unit 40B. I haven't done a project that's that small. There's a number of administrative requirements that need to file on a yearly basis. We're going to be exploring that during the next 2 weeks.
Mr. Can I do the chair?
Oh, yeah, you can ask any questions, yeah.
With a 4-unit 40B, just one of the units is affordable?
It'd be 25% correct.
We've been looking for a friendly 40B.
Yeah, we can explore that. So that's the
It'd be exciting.
That's the plan. So the plan is to have it be a rental, and I guess.
And
the-
all 4 units would add to our inventory? It'd
Correct.
be lovely.
Correct. So it should work. I guess the septic system is built for 6 bedrooms, and that is up and completed and running. So I don't imagine that we'll have a lot of administrative hurdles. There's going to be a considerable amount of renovations to the existing structure.
I only speak for myself, but welcome.
Yeah, I think it would be a great project.
Okay, I'll entertain a motion to allow the applicant to withdraw without prejudice. And John, why don't you be the voting alternate on this one?
Sure. So,
So
second.
moved and seconded by John. So take a vote of the board. All those in favor?
Aye.
Aye. Opposed, none. And
Do you have any time frame when you might be back?
I would say within the next 2 months.
okay, now I can't take the next one until 7:30, so let's see if I can
4
fly
minutes.
through the August minutes. It's the same way I just did with the July ones. So
Mm.
August should be near you or in front of you. There should be some August sets in here. If you don't have them, this I think is on this.
There are no August minutes over here.
Let's see if I can pass you some. Here's one August set. Here's another August set, another August set.
Is this the one that we met upstairs?
Yes, it was the one we met
So
upstairs, I'm
that should
pretty
be
sure.
corrected then.
Wait, let me just, any more down here you need? Okay.
The 2 months.
So on the August set, I saw that we had approved some minutes, look at that. And then we had a little time to kill, I guess I gave us an update on the proposed senior housing bylaw. In that next sentence, the proposed zoning bylaw amendment will be on the fall town meeting. There's another proposed bylaw for inclusionary zoning. The next start of the paragraph, there will be one more, is going to be another bylaw about inclusionary zoning. I'm crossing that out. I think it was typed twice by mistake. And then it's going to start, there is one more public hearing for the senior housing bylaw. It'll be posted as a joint meeting so members can attend and participate. Some of the points discussed were no minimum lot size allowed in any neighborhood, no age restriction, all that's fine, okay? Going on to the next page. Down to 7:45 PM, the discussion of Wildflower Meadows, down 4 lines up from the bottom, Chair Gould stated that under 40B comprehensive permit, I want to put in the word regulations. The board has to determine whether it's a substantial or an insubstantial change, and determined if it's insubstantial, it can be discussed. If it's a substantial change, the developer can withdraw or a public hearing will be posted. Then polled the board, it was unanimous, this is an insubstantial change. Then the next paragraph, beginning with building inspector, zoning enforcement officer, doesn't belong there. I'm going to stick it in the next sentence, in the next section, because right here is the vote that we voted it was an insubstantial change. Then going on to the next page. Again, just a couple of grammatical changes. I don't think I have to go through them all. Somewhere in the second paragraph, I'm going to add back that sentence about the building officer saying that the definition includes fences, just so it gets in the right section. And
Can I ask a
then,
question?
yeah,
Did they finish the landscaping?
yes, it's in here. I'll steer you to it in a minute. There's a lot of reference to the attorney Mark Bobrowski, that was their representative, and she calls him Gragowski. And since Mark Bobrowski is the Massachusetts lawyer who wrote the book on zoning, we should get his name right and spell it correctly. Next, down here it says Chair Gould, there has been significant progress. I'm just going to put in Chair Gould stated there's been significant progress. And then discussion about Attorney Alex Para wanting security, and we saying that the holding the last unit is adequate security because so much had been done. And then if you look at the very last paragraph, discussion 15 Great Road, you had asked there to be an agenda item for the fencing along Great Road, and that's the whole discussion about you wanting a higher fence and then we pulling the neighbors.
No,
in.
I just wanted to know, since these minutes were from August,
Right.
did they, before winter set in, finish the landscaping?
Yeah, I believe they did. I think that there was,
That's just a curiosity.
yeah, I think there were a couple
Nothing to do
meetings
with these minutes.
upstairs. I think there were a couple meetings upstairs with Gallagher and zoning
Roland.
enforcement officer and Shelley, where they discussed all this because he was trying to get them to release, he had a son living in one unit, and he was trying to get them to release a for-sale unit, something about, Roland wanted to hold the last unit, and he was trying to exchange units or something like that. And we disagreed. We said, the board voted very clearly, you have to hold the last unit, so move your son out, let the people buy your son's unit, and hold off for the last unit. So he did everything he had to do. And
Okay.
the last unit was finally sold off.
Okay. I'll make a motion to approve the minutes as amended.
And let's see, what did I do so far for alternates? Kitty, you want to do it again? Okay, Kitty's the alternate on this one. May I have a second to that?
Second.
All those in favor?
Aye.
Okay, the August minutes are approved. And I just need to make those notes, and then it's 7:30, so I'm going to open the discussion of case 695A, Kimball Farm Village on the Common, request for an extension to act on the comprehensive permit and update for the 40B project. I need to recuse myself as I have some dealings with the applicant. These two pieces of mail are germane to this discussion, and I need to leave the room. Cheryl will be acting chair for this, and I think Mark's been here start to finish as at least one voting alternate chair. And Jeff has to recuse himself.
1, 2, 3, 4, and 5. Kitty, you were here for at least one discussion on this.
Yes, in
So I'm going to
August.
appoint you as the alternate for that.
Good evening, Robert Ansel for the applicant. We are here seeking a 6-month extension of the comprehensive permit. The board members are very familiar with this project, so I'll provide a brief overview of where we are and to provide you with an update. And I think that we would probably be better served through a question and answering basis than a long discussion from me. But
Quick summary.
what's that?
A quick summary would be great.
Yep, so I represent Kimball Farm Village on the Common. We have been before this board on numerous occasions requesting extensions of the permit. I have been involved with this project since the Kimballs acquired the property, which was acquired through foreclosure. During the last number of years, Michael and Peter Kimball were having discussions as to what to do with this property after they bought it through foreclosure. They eventually ended up deciding that they would part ways. Michael Kimball sold his interest in the various Kimball entities to Peter, and Peter, that transaction went together late this summer, early fall time. Since that time, Peter had next to nothing to do with the real estate ventures of this project. Peter's been thinking about what he's going to do with the property, and in the interim is seeking an extension of the permits. We need an extension if the board doesn't make a determination, or if somebody had said that we didn't substantially complete the project. By way of background, during the past year, approximately $3 million has been spent on a wastewater treatment plant. The wastewater treatment plant services this property, and it also services the property in Westford. The bed that you see on the western side that's adjacent to 495 is a leaching field. The actual sewage permit and the operation was built in Littleton, where it was originally scheduled to be built for this project. There are 3 beds that comprise this septic system. 2 of them are in Littleton, and 1 of them is in Westford. So all the work wasn't necessarily done in Westford. What had happened from an enforcement standpoint is DEP said that the Littleton, or the ice cream operation, needed to fix their septic issues. When DEP looked into this issue, they also mandated that they require that the septic system be built in any adjacent properties be part of a major wastewater treatment plant. There was some effort to get other commercial tenants or owners, I should say, in the area to join in that effort. Eventually, the decision was made to build a wastewater treatment plant that just serviced the Kimball properties, both in Westford and in Littleton. Last Monday, there was a selectmen's meeting where the discussion came up as to a request for a 6-month extension. The selectmen unanimously voted in favor of the 6-month extension. The chairperson was at the meeting, and as was town council. I guess one of the legal issues is whether or not there has been substantial completion of the permit. My understanding after listening to the hearing is that Attorney Harrington said that he would rather not get into a discussion as to whether or not substantial completion had occurred through the building of the wastewater treatment plant, and the selectmen unanimously voted in favor of the extension of the permit, although the extension of the permit is not within the purview of the selectmen. It's within the purview of the ZBA members. So that's kind of an update as to where we are. We have asked for a number of extensions during the years. It's our position, our legal position, that we have substantially completed the permit since we started the wastewater treatment plant. As the ZBA members are well aware, I think certainly during the course of this project, Littleton has seen a tremendous amount of growth, and there's certainly a considerable amount of interest in doing something positive with this property, if not building out this.
Mr. Ansel, our purview is the 40B, not what else is done. And you are right that the selectmen voted unanimously to support the extension. In fact, I'm going to read the letter from the selectmen. From Keith Bergman, this will confirm that at its meeting July 8th, 2018, the Littleton Board of Selectmen voted unanimously 5-0 to support the Kimball Farm Village on the Common. It's a request for the ZBA for a further 6-month extension of the Chapter 40B comprehensive permit for parcel U07-19-6, 41.45 acres on Robinson Road. There's also an official request for said extension for 6 months. I want to correct you in a couple of things, because either they were stated, I'm starting the Q&A. Either they were stated wrong in our January 2017 meeting, or you have your facts a little confused. In January, it's dangerous having these old meetings completely recorded. If you ever have any question, LCTV, just go on zoning, and you can review exactly what was said and what exactly was happening. It's a little tedious to watch, but on the other hand, you get your facts up to date. Back in January of 2017, you told us that $1.5 million had been spent on the system to date, and that another $500,000 was expected to be spent, for a total of $2 million, not $3 million. And that figure threw me, because I heard $2 million before and it stuck out in my mind. So I think that a little exaggeration is going on there. Also,
I'm reiterating what my client informed me, and I understand that I actually put in writing that it, at that time, that it was, the estimated costs were $2 million.
That 1.5 million had been spent, that they were rushing to complete it by April so they could open the farm and be allowed to continue their business of selling ice cream, which they succeeded in doing. Yes.
Correct.
Then we asked you to come, we gave you a one-year extension at that time. I would remind the board that the original permit was granted in 2004 after hundreds of man-hours by this board to come up with a comprehensive 40B permit. And I wasn't on the board then, but I watched some of the read minutes, et cetera. A lot of man-hours went into getting this permit done. Kimball's bought it in 2011. Now, it was in the possession of the two Kimball's brother, whether it was, I don't buy the argument that it is a new person, because one Kimball bought the other Kimball out this summer. But the bottom line is, I went to the selectmen's meeting, and the point they made to me was that kind of really bothers me, because no one is pretending this 40B is going to be built as the man-hours that were spent to permit this. But what they would like us to do is to give a 6-month extension as a sign of goodwill in their negotiations with what should happen with this land. That might be in the town's interest to do. My personal opinion is that this permit, outstanding permit, is keeping other 40Bs and friendly 40Bs from coming before this board. I've heard statements, I heard a statement from a builder when I suggested that he could bring a particular parcel of land as a friendly 40B, that not only were we over our limit, but we were with Kimball on, with the ones pending, we'd be way over our limit. And that he didn't think it would fly, and I tried to convince him otherwise and wasn't successful. But that is neither here nor there. The bottom line is that this is a very old permit that's very outdated. It goes back to 2004. I would open questions.
I have a question.
Oh, and I appointed Kitty, that's
No,
right.
I have a question. What does the 40B permit, I assume it says there's X number of units going to be built and so many going to be,
It has huge amounts of detail,
Yeah.
right down to what trees will be planted where.
so my question really goes down to, what's going to happen in 6 months? If we give you 6 months more
They
to
have-
do this, what are you going to come in here in 6 months to show us? I mean,
If-
obviously, you're not going to have the buildings built.
No, but if they can make substantial completion towards this, if they suddenly swoop into high gear, pull a bunch of permits, and spend the next 6 months building these units, then they'll need an extension from us.
Okay, so
The
that's.
thing
what-
is, they haven't done a thing.
I understand, so my question, I guess, to him is, what are you, what guarantee, or what are you planning to have show us in 6 months? Are you just gonna come back in 6 months and say,
Ask for
oh,
another
I need another 6 months extension, or another year extension?
We, at the last meeting, we told him no more extensions.
I remember that.
Yeah.
So,
Very firmly.
And that's what I remember, and that's one of the things that has me bothered about this. And just like you were saying, what are they gonna show us in 6 months? Are we gonna be back here talking about another extension for something that's now 13 years old, and who knows how much different it would be if they had to go through the permitting process again?
I don't think we would be, we are an autonomous board. We act as our good conscience and intelligence and knowledge and abilities and views lead us. Nonetheless, we are an appointed board by our Board of Selectmen. Our Board of Selectmen has asked us to grant this 6-month extension. We do not have to, but they have asked it of us. No one is pretending that this 40B is going to be built.
so that goes back to my point. What will happen in 6 months? That's what I think, so that we, 6 months from now, we can go, oh, okay, you now have a full set of plans and contractor on line or whatever. I'm with you, there's no way you could have trouble building a house in 6 months, never mind
Well,
the
if they
whole
even
40 days.
started, if they pulled the permits, if they did, if
Exactly.
they did.
So I'm just asking him for him to tell us what they plan to have done in 6 months.
He just said they're not doing a thing. What they're doing is they're negotiating with the town on other, I'm sorry, you didn't say they're not doing a thing. I apologize. What they are doing, what was said at the Board of Selectmen's meeting was that there are ongoing negotiations over this piece of land with the town. And they would like, as a gesture of goodwill from the town, for us to extend this permit.
But on the
Because it
other
is an
hand-
important piece of land in play that our town selectmen believe they should have options for.
And if they're negotiating other uses for this land, it does not require extending this permit.
I agree, but our selectmen have asked us to extend this. I stood up and said that at the Board of Selectmen meeting before the vote was taken. Nonetheless, they asked us to give them a 6-month extension,
May I ask a question?
of course.
So I understand I understood you to say that basically since Peter bought Michael out, Peter was thinking about what to do with the property and that's what would materialize hopefully at the end of the 6-month extension. So I misunderstood you. But what I don't understand, and this shows my youth on the board, not my general youth, what happens if we say no? What happens to the permit?
The permit ceases to exist. They could take us, I'm going to answer that, because
Go ahead.
permit ceases to exist. They could take us to housing court and say that we had no right, that they had done substantial completion by putting in the septic system that included this project, and spending $2 million doing it. They could say that they have, that we had no right to cancel the permit, and they could take us to court. And that is a possibility.
Yeah, but the septic system would have been built if it hadn't been the EPA saying the ice cream store doesn't get to open.
Yeah,
I
and it
know,
was
but
built
nonetheless, it does include this
I
project.
understand.
And it was built to support the Westford facility, not directly for this facility.
Mr. Ansel, did you receive the letter that we requested detailing what was done on this property?
No, and the first time that I heard about it was you stating in your minutes that you were going to ask me to do something.
May I make a suggestion? In the future, when no one is present for a report on things, you go back and look at our meeting, because you'll find out exactly what was said. And I apologize that
Okay, but
that letter wasn't, it's not your fault that letter wasn't sent. Do you have any details on the septic system? Do you know what was built in Littleton on that site, if anything?
I can relay what I was told verbally, which is that the wastewater treatment plant was built in the same, so I should start from the beginning. When this project was started in 2004, they built a considerable amount of infrastructure, and they actually started on this project is 108 duplex units, and 8 of the units were partially constructed. Since Mr. Kimball, or the Kimballs, had bought the property on one of our extensions, we were told that we needed to shore up the units because some of the units had been vandalized, and we needed to do some work on those. $130,000 worth of work was done that I could look at my notes and figure out when that was done.
2012.
Okay, I was going to say, for sake of discussion, it's at least 2 years ago, and it might have been 2014, but still 2 years
I think it was
past.
2012, it was right after they bought it. But I could be wrong. I'm sorry.
Say it was 2000, so one of the things that happens is that whenever you have a permit, you have to do something which is called substantial completion. Substantial completion is a legal term. If you don't use a permit for a period of 2 years, your permit will lapse. So if this board grants a variance, say for your standard variance that comes before this board to do something in the lake area, so somebody needs to put on a deck or whatever they end up doing. If you don't act on that permit, it lapses. And I think that Littleton has a bylaw for relative to standard variances that you have 12 months to act on that.
I'm going to interrupt you. In the case of 40Bs, permits are for 3 years. They have to do substantial completion in the original permits in that 3 years, and then they're supposed to complete it within 5. And so this project nominally should have been completed by 2009.
And in my legal world, substantial completion is usually defined in.
So there were units.
AIA
built.
terms, it's from from a planning standpoint, while they look at it, is whether or not it's, the infrastructure is in, because that's what the municipality's interest is. It's not necessarily that the units be constructed, but you can also have lapses in your period. So you can't get a subdivision approved, say, for instance, and then sit on it forever and then go back and try to build that because zoning may have changed and we are in a different context with 40B, so perhaps that wasn't my best analogy, but you can't sit on a permit forever. What happened in this situation is that the original wastewater treatment plant for the 108 units was constructed. It never went online. None of the units were sold, but it was approximately 3/4 of the way completed, so because they weren't going to be able to sell those first group of units unless the wastewater treatment plant was completed. Eventually, that wastewater treatment plant ended up going by the wayside DEP.
My understanding was they hadn't put it in at all,
That's not true.
the original owners.
No, there was a considerable amount of work that was done with the original permit. It didn't get completed, and I don't know as though
It got abandoned in any case.
it got abandoned, and I don't know as though
Old technology.
I know that it was old technology, and there was some discussion on the Kimball side years ago whether or not they would have been able to rebuild that wastewater treatment plant, or they were going to have to put it in a different location, or they were going to have to do something different with that.
I'm going to interrupt you just for a second. The original owner, the original permitter and owner of the project got as far as building 8 units. One of them was complete enough that it was under agreement, and it was a lovely show place. The original permit had 108 units, all with floor master bedrooms, perfect, and 1-car garages, perfect for senior citizens. Basically row condominiums, really quite a nice project. And unfortunately, the builder went bankrupt, or the property was foreclosed on, or the property went, how would you put it? That
It went to foreclosure.
Went to foreclosure. When it went to foreclosure, there were a lot of contractors that were owed. My understanding is there was a lot of contractors that were owed a lot of money that went in and ripped out the appliances, the plumbing, the woodwork, a lot of damage was done to the units, and they were not, occupancy permits, I don't believe, had ever been issued because the septic systems weren't complete. But there was one unit that I went to an open house on that was really quite lovely with hardwood floors and all sorts of nice things. But then, after Mr. Kimball bought it, we gave him automatically a 3-year extension. And I think you're right, it was 2014, because
I think so.
yes,
There had been no activity.
2014. After a 3-year extent, we automatically gave him a 3-year extension to build the 40B as it was when he acquired it. When in 2014, nothing had been done, we were hesitant to give him another extension. He did a little bit of cosmetic work really fast and sent us a bunch of pictures of workmen painting these buildings and planting shrubs around them and making them exterior-wise look good again, and claimed he spent $130,000 doing it. We have no reason to disclaim. But then nothing else happened, and that extension at that time we gave him, I believe, was 2 years? 2014?
I think,
Or a year, just
I
one?
think it was a year, and then we got another year, and then we got a 6 months, and then I got another 6 months. Bottom
This
line-
last one was a year.
Correct.
And-
I think I got 2 6 months.
And then a year one.
And then a year. And that's where we sit today.
Because it's no fun having you come here again and again. But that brings us all back to the present. where we're being asked by our selectmen to grant a 6-month extension because they are in negotiations with the current owner on things that can be done to the land. It was pointed out to me that that is a important piece of land for Littleton Common. It's right next to Littleton Common. There's all sorts of options for senior housing and some development that could be done there. And they feel like they are in a more position, I don't understand why, because I keep telling them a friendly 40B can come in front of us, but they feel they are in more of a position of strength and goodwill if we grant a 6-month extension.
May I ask a follow-up question on?
Of course you may.
So if I understood you correctly, you said that substantial completion has to do with the infrastructure, and whether that's,
It
progress
can.
has been
It
made.
can, there's a bit,
Okay.
there's.
But is anything besides the wastewater treatment plant, which was done this past year, anything else done with infrastructure in that parcel of land?
I don't want to use, I am going to use the legal term, but as a practical matter, the roadways are substantially complete. I'm using the word substantial completion, which is the legal term, but you can actually drive through the project, and there has been a considerable amount of infrastructure that is done. I
But
think
that
one-
was prior to 2011.
I was going to say that you can have, like what I was trying to say about the Long Lake example is that if you don't use your permits, eventually they lapse, okay? So that's true in all of zoning contexts. So that, if you have a pre-existing non-conforming use, that whatever that might end up being, if you stop using that for a period, you can't reestablish that use. So if you have a commercial business within a residential district and you stop doing that, you can't have somebody then come back and say that I want to go back into that same business. So from a legal perspective, our arguments would be that the fact that we couldn't do anything with our project as far as moving it forward unless DEP approved our project. They said that since we have adjoining properties, even though they're different ownership, the DEP's order said combine both of them and create a single wastewater plant. So we did that. That was completed, as was stated, it would have had to have been completed by our time that we opened. I actually think it ended up getting completed in April, May timeframe. So our legal argument would be that we've completed we've substantially completed the permit. One of the things that gets a little bit, even a little bit more confusing in this is that the original decision, which is very lengthy, says that not only did you need to complete your infrastructure, you needed to sell a certain amount of units at a certain amount of time, because what they wanted to do is to make sure that the developer didn't wait to the end of the project to sell all the affordable units. So they said you have to sell. There was production deadlines. There were a lot of details that pertain to various timeframes throughout. Our legal argument would be that we don't need to be in front of the Zoning Board of Appeals seeking an extension because we have substantially completed our permit and we can go forward. There would be nothing that would prevent us tomorrow from going to the building department and getting a building permit to build more of our duplexes or finish out the work that we've done. So we don't really need to be here. That's what our legal position would be, but to the extent that we are here, our position is that we've either completed it, and if we haven't completed it, then give us a 6-month extension to June 30th so that we can continue to build it out. The answer to your question about substantial completion is that we don't need to complete 108 units within that period of time. We would need to get our infrastructure done, and I think that we're fairly close to that. I guess a legal question would be is whether or not the fact that we've now had the project since 2011, have we abandoned that, or we wouldn't have abandoned the permits, but have they lapsed through non-use?
I'd like to, does anyone have any more questions for Mr. Ansel? Because I'd like to close the hearing and have a discussion among ourselves.
Yeah, I'd like to know how you can consider something substantially complete.
Is that a question for
Yes.
Mr. Ansel? Okay.
How something can be considered substantially complete when there's essentially no units available for rent or sale.
Because it's an infrastructure basis, so
And I personally don't accept that. That doesn't make sense to me.
I
You can have a nice road and do nothing and not put the units in that the permit allows, and you consider that substantially complete. I'm not happy with that.
Okay, so
understand.
I will make a distinction just so that I address your question. There was a case that was, I think it's in Northborough, which was a non-40B condominium case that what had happened is the project, the roadways were built within the project, but the units were not built. The developer, years later, like 20 years after, came back to the town and said, I want you to issue permits for building. And the town's position was that your permits have lapsed because you haven't used them for a period of time. The court's decision, and this is a factual-based determination, there's more things that would go into that, said that your infrastructure was done, in the town you have to issue permits. But our situation's a little bit different because, not only because of the 40B context, but also because this decision says that you have certain production deadlines that you need to meet, and those have not been met. My position is the extensions that we have gotten is that we're back to where we are from a time frame on those periods. So what had happened in that, I believe it's Northborough, if what the board had said in that decision is that you have to get everything done, say, before December 31st, 2010, or whatever that date may be, then that's when that permit went to, as opposed to the fact they didn't have a end date in that permit, and the court said you have the right to continue to build that because you have substantially completed the permits for the sake of the infrastructure. So I don't know exactly where we would come out here, and I ask your chair to correct me if I'm wrong, but your town council said that he would want to avoid having that argument. That's what he had represented to.
Our town council would like to avoid in Littleton being in any kind of lawsuit. I think we can generically say that. Nonetheless, our town council also has expressed the opinion that we have dotted our Ts and crossed our Is and have done the things that we need to do. Should we end up in such a lawsuit, we are as proper as we can be. Alan?
I just am not really clear about the wastewater treatment plant. Is it completely constructed at this point?
Yes.
And it is functional?
Correct.
And is it located in Littleton or in?
So there are 3 leaching fields, 2 of them in Littleton, 1 in Westford.
Okay.
There is a single wastewater treatment plant, which is in the town of Littleton. When DP issued its consent order, there's a note that says that if you can combine the adjacent.
Mr. Ansel, Kimball owns some land in Littleton that's not part of Kimball Farms. Is that waste treatment plant on the 40B property, or is it on the Kimball property?
It's on the 40B property.
It is on the 40B.
It's on the 40B
Because
property.
I got to tell you, in the January 2017 meeting, we were led to believe it was not at all on the Kimball Farm property, and there were a bunch of neighbors here very pleased with not in my backyard, it's in Westford now. So I'm a little confused because that's what we were told back in January 2017. I went and watched that meeting because I was confused when I was told that there was some of the waste treatment plant was actually in Littleton, which is why in the meeting in July, notes, the summer meeting that we had when we asked for progress, that we sent that letter asking for the July meeting, when we asked.
I'm sorry, July of 2017?
July of 2017, we requested our secretary send a letter to you asking if there are even any plumbing for that septic system in to the 40B property. So I'm a little confused and would like to see what part of, do you have any records of the septic system at all? Would you
No.
please be prepared?
I will do whatever you ask me to do. I'm reiterating that what I have been told, and I can submit plans to the board, that the wastewater treatment plant was built exactly in the same location as the original 40B wastewater treatment plant location. And a wastewater treatment plant you have a wastewater treatment plant, and then you have leaching fields. The leaching field that is built in Westford is not the wastewater treatment plant. You have a wastewater treatment plant has it's a big, giant football-sized thing that has various chambers of moving effluent, and it separates out things.
So, right at the moment, the wastewater for the Westford ice cream stand and its facilities are all being pumped over to this 40B for the,
And then it gets leached out in the field that is close to 495, so I believe.
so then it gets plumbed all the way back over under 110 to 495. There are leach fields supposedly built in the 40B for the 40B
Correct.
that haven't been built yet,
No.
that have been built.
Yes. It's my understanding that the system is complete.
But they're not being utilized by.
Correct. And so that what they did is they reserved flow for that. So the system is built for the 108 bedrooms that we have there. Right now, that if the system has excess capacity that is over and above for the ice cream requirements.
That would accommodate at least 108 units, and I suspect some other things too, which is why our town fathers are probably interested in this piece of land.
So
If I
what
can-
does this,
sorry.
what does this do? Initially, the waste treatment plant was designed for the 40B.
Only for the 40B. There were no
Right,
adjacent parcels.
Right. Now, it's a waste treatment plant serving the Kimball property, and the 40B will tie into it. So it's no longer really a waste treatment plant for the 40B. So how does that do anything to violate the comprehensive permit?
Well,
DEP has the right to ask people to combine them, and if people ask DEP to combine them,
Oh, yeah, I
then
understand
I
that.
don't know who, the chicken or the egg. I don't
Yeah,
know
but
whether
this-
Kimball's asked to combine them or DEP said, Jiminy Crickets, look, next door to you, there's another piece of property, why
I
don't you
understand
combine
that, but
it?
as a minimum, it sounds to me like there has to be an amendment to the comprehensive permit.
I don't,
I'm sure that there would be. I'm sure that there would be a need, because there's certainly going to be cost-sharing relationships, and there would be a need for that. Because you can't say because it's all in the 40B project that it's 100% their responsibility. So we would need to do some
Substantial.
cross easements, and we would need to do some changing. I just want to answer, I will totally address your question. The consent order from DEP says that all sites in an approximately 41-acre parcel of land abutting the south parcel title to which is held by Kimball Farm Village on the Common LLC, and more particularly Level Black, shall be made part of this consent decree. So DEP said that we needed to combine the two parcels. We needed to create one wastewater treatment.
Yeah, and that's fine. All I'm saying is it's not really per the comprehensive permit at this point.
It's not per the comprehensive permit, correct. So, I mean, you could say that, did we act on that? Is that substantial completion of the permit if it's something different? I don't know. DEP ordered us to do the wastewater treatment.
So right now, effluent from the Kimball Farm facility comes to the plant, then goes back to the field by 495.
That's certainly
When
my
that-
understanding. I am not.
So my next question is, these houses get built, the effluent goes into the same system, but suddenly that amount of effluent is going to go into the local leach fields and not the ones over at 495? I'm not sure how that would work.
I have no idea how to answer your question. I'm sorry. If you wanted to continue the hearing, I can get you a summary of how the wastewater treatment plant is designed, and I'm certainly be willing to do that.
I think if you were to act on this somewhere along the line needs to be a modification of the special permit to cover the
Absolutely.
situation.
Because they can't make the burden of the wastewater treatment plant 100% on the association.
And I would make an argument in that case that it would be a substantial change
Yes.
as opposed to the insubstantial changes we've made to 40Bs in the past and we require
Absolutely.
reopening the original hearing. But that's if we grant the
Yeah.
extension on this
Right.
permit. Alan, you started to ask a question, I'm sorry.
No, I did ask the question, I got an answer.
Eric, any questions?
Not so much a question as comments.
I'm
I mean,
gonna have
obviously
some
share the board's frustration with every 6
Okay,
months. a year
I'm
coming back.
gonna close the hearing, and we're gonna have some discussion. Do you, any questions? Because once I close, you can't ask him questions.
Well, okay, I do have a further question. I think it was kind of asked from the Kimball's perspective, what do they hope to accomplish in the next 6 months? If we allow the extension?
The next statement that I'm going to make, I am making 100% cognizant of a statement that was made earlier by your chairperson, which is that it's hard to say that the property is under new ownership from the change from Michael and Peter Kimball to Peter Kimball. I have known Michael and Peter Kimball my entire life, and they are very, very different people. And Peter, to him, this is a new project and a new property and something that he has not been involved in. That's been Michael's world. I think that he needs to realize that there are no further extensions, and that if he's going to build this out, then go forward and build it out. We had tried for a number of years to market the property rather unsuccessfully, and I think that this is, especially in light of Littleton's popularity and growth during the last couple of years, it is a saleable project. I'm not so sure it had been up until then. So a decision is either going to be made to build it out, which I'm not so sure will happen, or the decision is going to be made to do some kind of a active adult kind of project, whether that ends up being under 40B, your new zoning bylaw, or a new proposal. So I realize that I'm not exactly answering your question. I think that what will happen is the decision absolutely has to be made, and I realize that from a credibility standpoint, I've represented that to the board before, and it hasn't happened. I think some of that was the uncertainty between the brothers, uncertainty about the economy, uncertainty about whether or not Littleton was going to pass a new bylaw. All of those things have now happened, and we also have a project that now is viable and saleable. So something's going to, I'm confident that something's going to happen in 6 months, and if it doesn't, then I
You'd be too embarrassed to come back.
yeah.
Enough room for
Never.
Bartlett.
No, I don't know. I mean, it's crazy.
I think Mr. Anderson's not quite comfortable here tonight.
Look, I've been here in front of you since 2011 asking for extensions, okay? And we have been trying to get our act together. There has been some uncertainty with what they wanted to do with moving this project forward. Those answers should be readily available now. It's time to focus on this thing, or just say, you know what, it's going to be part of Kimball Farm for the next 50 years, and nothing's going to end up getting
So
built.
just to paraphrase that, essentially it provides options that you would not have if we didn't extend it.
I think so, and I think that we, from a value standpoint, a property with permits versus a property without permits is a radically different.
But you know what, Mr. Ansel, I have trouble buying that because Mr. Kimball was able to buy this property very cheaply. And so he would not lose money selling it with or without permits. you know, I have trouble.
And also, we have a wastewater treatment plant now, so, and that can be used for different uses, and, you know, it is zoned for single-family homes. Before the wastewater treatment plant was in, building septic systems here might be difficult because there is shallow groundwater. This is a very valuable parcel of land
You know, whether it
now
has a
that
permit or it doesn't.
doesn't have.
It really is. But I'll keep coming back to this. At the selectmen meeting, the town father said, is there negotiations on what to do with this piece of property? They asked us if we could get a 6-month extension so that they could show goodwill and continue their negotiations on this property.
Is there enough room for a par 3 golf course there?
There already is one.
Yeah, it's that, and, you know, the parcel extends now all the way to the Tubing Park. So not the 40B parcel, that there is a
There's
large,
full golf.
right?
You know, all
Our
of this
question,
makes
Doug?
me, all this makes
For-
me
for
really
the ones-
very grumpy, because in 2011 or 2012, I remember begging Mr. Kimball and Mr. Ansel to please pull permits so that we could add it to our inventory and have some control over Wildflower Meadow and the Great Road building. And they said they would, and they never did. So that made me really quite grumpy with this. And personally, I think that a lot of man-hours went into the original permit. It would have been lovely if it had been built, because they were quite pretty units with first-floor masters that would have provided quite a bit of senior housing. And if we'd had that senior housing since the original permit of 2000, but since 2009, the town would not find itself in the position of the lack of senior housing that we have now. So,
Move
I
to
have-
close the hearing.
Second.
Second.
all those in favor?
Aye.
All right.
Discussion.
You're looking at me.
Well,
I want
that, you know,
I'll
he only
start,
needs a
okay.
majority.
yeah.
So keep that in
Needs a
mind. You want to
majority,
poll the board?
3 or 4, or 4.
There's 5 of us, I pointed Kitty.
Yeah.
So he needs 3 out of the 5 of us. I don't know, having closed the hearing, can we continue it if we want to?
Sure. Well,
We're
reopen
going to
discussion.
reopen it.
Do we have to reopen it?
Yeah. Okay, so it takes 3 of 5.
I mean, if we want more details on the septic system,
And I will turn that around in a week if you want me to do that.
if we want more details on the septic system, or we want to hear from our selectmen, we can ask for both of those things and continue the hearing.
Yeah, but
If-
we'll
if
make a
that's- if that's-
decision tonight, so it'll be a moot point. It'll be just
Well, I mean,
information.
saying we cannot make a decision tonight. Do you want to poll the board first and decide whether or not we want to continue it and ask
We have
for?
discussion first.
Sure.
I mean, I'm just looking at the brass tacks of this. I mean, we're in a situation where it's been an uncomfortable rodeo, right? Back and forth. The original permit precedes me and my tenure on the board.
I think it precedes all of us but Sherry.
But nevertheless, I mean, it's been back and forth, and it's been uncomfortable in many cases, I grant that. But we're now in a situation where, the situation on their side of the table has changed. The ownership has changed, it's very different now. We also have a situation where the town, through the select people, have basically been obviously involved in some discussion, obviously see something here of merit to want to go in this direction, and unanimously have asked us to grant an extension, which provides us with no harm. There's no harm in doing that. And if we were to say, well, you know, the heck with that, you know, we're going to stick by our guns and we're just going to refuse to do that, and now we get in a situation where we've got the zoning board of appeal at odds with the board of selectmen. That's number one. Number two, if we do deny it, and then they decide, well, we're going to go to the state, right, and appeal there, we're in a very vulnerable position on the face, number one. We're also in a vulnerable position about having town support for us in the midst of all of that, you know, legal goings-on, and it's not clear to me where town council is going to find himself in the middle of all this back and forth. I think there's very little downside on granting the extension, I mean, from what I'm hearing. And there could potentially be very good upside from granting it. So I'm just on the brass tacks of it, that's how I see the situation.
Mark?
Yeah, agree with Alan essentially. I mean, yeah, we're all frustrated with the repeated requests. You know, we spent most of the time talking about the wastewater treatment plant, which I think really doesn't have any bearing on what it is we have to decide. You know, I always look at, well, if we say no, what happens? Well, Alan already detailed some of those. There's no advantage to saying no, whereas we know that, okay, the Board of Selectmen and other people in town seem to think that, no, it's probably worth pursuing, let's say pursuing status quo, pursuing the project with the permits in place. So that, to me, is sufficient for me to support extending it for 6 months. And I'll say the same thing I did last time. Let's just do it for a year, so we don't have to do it again in 6 months. But I'll let the rest of the board decide that and how the motion goes.
I'm going to go ahead and step in here with my thoughts. I'm only for a 6-month extension, and I think that this should be being brought back to us as a friendly 40B, that this permit is out of date, old, and should be allowed to expire, that things have changed dramatically, fire regulations, building code, all sorts of things have changed, and to reenact this permit and to carry it through is going to create a lot of substantial changes and cause the public hearing to have to be reopened, and that we really should be doing this under a friendly 40B. That being said, I have to agree with Alan that our town fathers selectmen fathers, whatever you want to call them, have asked us to do this. There are negotiations. They tell us within 6 months they hope to have resolved some negotiations. I would put a fire under both our Board of Selectmen and our petitioner by saying that this is it. We said that this is it before, but I would put a fire, figure out what you're doing, or else come back as a friendly 40B, and let's get some couldn't you imagine a senior housing development there with little golf carts? People could take their grandchildren over to Kimball, little path through the woods for the golf carts, it could be a wonderful place.
I'd go for a golf course.
Well, you got the golf carts, you'd be dual
It could
purpose.
be, all sorts of wonderful things could happen for the town. And I'm hoping that's what our town fathers are working on and why they've asked us to give them a 6-month extension. Kitty?
Well, I think I'm the newest member of the board, so I haven't had to live through all of these endless hearings and extensions on it. My gut reaction is I think it's ridiculous to keep extending this. And there's good reason to say no. Having said that, I can also see that the change in the landscape, both within the town bylaws and in the ownership, and that presumably there will be some serious thought and action being given by Mr. Peter Kimball as to what to do going forward. The selectmen, for whatever reason, I wasn't able to attend the Board of Selectmen meeting, but I did, in between working, watching bits and pieces of it, but it kept freezing up. But I saw you and heard some of the discussion that was going on with town council, et cetera. I think a 6-month extension, as Mark said, there's no harm in it for the immediate, but I do think that I would feel very strongly if somebody came back, and I don't agree with Mark in terms of a 1 year, because I think a fire needs to be held. 2004, it's a long time. I mean, I've had a lot of grandchildren since then, so I didn't work very hard at doing that, but I now have glasses, my husband has hearing aids, lots of things have occurred since 2004, and we're all aging in place. So I would say I would agree to a 6-month extension, but I would be extremely reluctant to go beyond that under the circumstances as I understand them to be presently. And I think going back to the Board of Selectmen with something in terms of how strongly we feel is appropriate. I don't know if this is something that could be done since it wasn't done from August, that letter detailing some of these issues with respect to the
Since we have
wastewater.
Mr. Ansel here, we can certainly say, could you please, for our next meeting, have the septic, we can ask that, and I'll ask that when we're done. I want to get, are you done?
But procedurally, is it not possible that he could be asked to send it to us in the interim, so we're not waiting for the next meeting to get the
Sure.
information?
Absolutely,
Sure.
and I'll do
some
that.
kind
do it in email form, and Shelley can just.
Engineering.
Well, what I plan to do is get a letter from the engineer with a summary of how the system works, what was built where, and where the flow of effluent.
Drawing
Yeah,
would
I
be
think
wonderful.
we're not allowed to ask him questions during
Sorry.
discussion.
Yeah,
Well, she's asking you, and he just.
and he just
responded.
responded, he left it, I didn't ask him.
But I think, in
Joe,
addition,
please.
well, to finish the thought, not just a description, since we've been told it's complete, then we ought to get a description of what it's complete, and maybe a drawing that shows where everything is, maybe a couple of photographs, I mean, just
Wouldn't that be nice?
just
if
show
we
it's
had that?
done, okay, well, show me it's done.
And what the flow is and that kind of stuff.
I'm not worried about it, they meter stuff coming and
Well,
going.
if-
I've worked in places where we have these systems, and they just
We
meter
are
it going in
extending
and out
the
different things.
existing permit, so we
Yeah.
should be thinking about what percentage. Are we gonna expect especially our low-income
Yeah.
participants to have to
So-
pay?
So I agree with the idea that 6 months, I mean, we extend it too long, then they'll wait, we give them a year, they'll wait till 11 months are gone, then all of a sudden work on it. We give them 6 months.
We've had
they
that
may-
happen more than
Be able to
once.
work on it in 5 months from now. And I agree with it, since the selectmen have asked nicely, and they obviously have something going on, and Lord knows whether it's the 40B they're hoping to build, or the home for aged, or whatever, or maybe just channeling sewage from the center of town and out to the septic system that exists. I don't know what they're doing, but since they've asked, and I don't see any harm in giving another 6 months, then, but we ought to be on record saying, this is it, guys.
We said that a year ago.
I understand, but the selectmen didn't ask pretty please a year ago.
Yeah, I know you're not done, I'm gonna come back to you.
The selectmen didn't ask pretty please a year ago, and they have this time, and so I know I'm not voting, but I would still think that would be something I would keep in mind, that, in good faith, we can,
Actually, I thought a year ago, Mr. Bergman did show up and say, gee, the selectmen has supported this, and that did lead to our discussion, but, okay, Rod.
Yeah, I'm gonna take a different approach. The fact that this has been going on and on and on since, 2004 or something, and these people have been pretty long as well. The fact that a year ago we said this is it, and they promised they'd have everything and so on. The fact that I don't like being directed by the selectmen, the fact that I don't like being threatened by the housing board and going to court and so on. I want to make sure to represent our frustration and grumpiness that there's at least one no vote.
Go ahead.
One of the things that interests me is, I think we would not be ill-served if we had some more connection with that process that's happening in the negotiation, not in terms of participants, but at least, and maybe you're already involved, but I'd like to have an idea of what's really going on there.
What I was told is
My
there
sense, if I could just finish, my sense is that there's ongoing and fairly, active negotiation going on, but I don't really know that. I'd like to know more about that, and as a board, I think we would be, within our, interest and ability to ask for, okay, can you give us some heads up as to what's going on, guys?
What I was told off the record is that meetings are happening with 2 planning board members and 2 of the selectmen members and the administrative assistant to the town manager. I don't understand why we're not being included in that in some format, so maybe we should send a letter back to the selectmen asking to be included in those discussions, 1 or 2 of our members in those discussions, some representation, I think would make sense.
Okay, thank you.
Especially if we're going
It's our
to.
permit that they're, that's allowing anything to happen.
And let's face it, whether we did it directly or not, this board spent hundreds of combined man-hours on this permit back in 2003, 2002.
And so on
when it
and
first
on.
came on and we granted in 2004. There was, whether there are predecessors or not, an awful lot of man-hours were spent on this, and it should be respected.
Yeah,
And
that's
we've
enough
spent
to
too many
say-
man-hours on it since then, ourselves.
And that's enough to say that it should be redone, because things have changed.
Yes. I would entertain a motion.
Move to close the discussion.
Second.
Oh, wait a minute, I think I'm supposed to take notes about who's making what motions. Okay, so who moved to close the hearing?
I did.
No, we did that already.
No, but who did originally? Back-
I moved to close.
Alan,
Rod, you did?
Here,
he's done
yeah.
at that end.
And who seconded it? Alan, was that you?
I seconded it.
Yeah, we were
Okay.
kind of tied.
Now, who's closed hearing? Who's Alan's closing
For
discussion?
discussion.
I don't really know if we need a vote for that.
Yeah, I don't know if we have to close discussion, but someone seconded it.
Rob,
Rod closed it.
Alan moved to close.
Close.
Yeah, I don't think
Discussion.
we have to close discussion.
Yeah, that's what I was just saying.
But that's okay.
Oh, we've done
it. And I have notes, and it's being recorded, so we're good. I would entertain a motion. Someone has to make one.
I would move that we grant an extension to Kimball Farms LLC, I guess it is, of a 6-month extension to the 40B application and decision and whatever you call it, permit that is in place.
So what we want to have, I don't have the agenda in front of them. I won't reference the, so you're making a move that we extend the permit
Well, why don't
for
we just
case
read what we did a year ago?
and substitute 6 months then?
Yes, it was moved by, well, I'll just read what we did last year. You remember I did it. It was moved by Mark Saucer to grant an extension to the 40B comprehensive permit for Kimball Farm Village on the Common for the period of, last year we said, 1 year, with the status report given to the board no later than June 30th, 2017, seconded by Alan Bell. The vote was 4-0.
And we
Okay,
say
so
6
let's-
months, but or a year, but that was, or 6
No,
months
no,
from
no,
now.
he's
should have been
reading what
from
we did last
month.
month.
Right.
So-
So my question is, are we talking about termination June 30th?
Okay, could you please pass that over to Alan? Alan, would you like to reread your motion? Substituting
Suitable
what
dates.
what,
Before it says it does, I'm saying we need,
Not just
we
6
should
months,
have a
but
date.
put an
Is it
actual
6
date.
months from when, from December, when he granted us a 20-day extension, or 6 months from today? Because the 1 year ran out in December. So
right,
it's 6 months from
but
that
I
date.
couldn't attend the December meeting, and we wouldn't have had a quorum of people who could be here.
From today.
What is it, what are the selectmen asking for? Do they have a
A
time reference?
6-month extension.
Yeah, and I'm saying
From
6
when?
months from when?
Didn't say.
I just
At the
moved it
January
today.
8th meeting, the selectmen voted for a further 6-month extension to the Chapter 40B comprehensive permit for parcel number U07.
Rather than cause grief over a 30-day, one way or the other, just do it from today and then you're covered.
Well, what I'm suggesting is the motion to say a date, 2.
Two, yeah, instead 6 months, say a big July 30th or something.
But that's
Done.
more than 6 months.
I know, but it's not, at this point, 2 weeks more is not gonna make a difference.
Yeah,
It's
but-
better than being a month short of
But
what
since the
somebody else
1 year
wants.
ran out in
Mr. Ansel has his
December.
hand
I
up.
don't
Is he
know.
allowed to?
No,
But
he's
since the
not.
1 year ran out in
I'm
December.
ignoring his hand on purpose.
We're giving him 7 months.
Sorry, Mr.
Because
Ansel.
the last one ran out in December, that's my
Right.
point.
I would keep it at 6 months. I would do.
I think pick a date, you pick a date, not just.
Okay, how about we do this? I move to grant an extension to the 40B comprehensive permit for Kimball Farms Village on the Common for a period of 6 months to June 30th, 2018.
Okay, don't put both in there. Don't say 6 months and June 30th.
It's like having
because-
2 watches, you never know which one's right.
Right.
It's either 6 months or it's until
June
June.
30th.
So
Yeah,
grant
exactly.
an extension to the permit to
Okay,
June, what
all
day of
right.
the week is June 30th?
Everybody goes with their phones.
I know.
June 30th is a Saturday, why don't you do the 29th?
Okay, June 29th.
So your proposal, would you read it one more time?
Move to grant an extension to the 40B comprehensive permit for Kimball Farm Village on the Common for a period of, well, until June 29th, 2018.
Okay. Can I have a second?
Second that?
All those in favor?
Aye.
Yes, aye.
Those abstaining?
As I stated, no, not abstain, but nay.
Okay,
So we
so
have one vote negative recorded.
two negative.
Well, we could do two if we only need a number of three to pass.
Okay.
How do you
Your-
vote?
We have 4-1. Your permit is extended till June 29th by a vote of 2018 by a vote of 4-1.
Thank you all for your
Now,
time.
now you can make your comments.
What I was going to say is that last time you had town council draft the vote, you did an oral vote, so you wanted to make sure that everything was done. And the only procedural thing that I could suggest, you don't have to do, is that you incorporate, the last vote that you did, what you said is, look, this is our last extension, we're angry, we're dissatisfied with the process. So I was going to say that if you wanted to take a vote, you could incorporate your prior vote, because that references your procedural history. And what you did is you verbally voted, and then you had like Tom or whoever.
Write the language for us that's an excellent suggestion.
So you could certainly do that.
We
You
probably-
did take a.
we will add that to it.
You did do a verbal vote, you're certainly covered with that if you wanted to do that, but if what you wanted to do is that, you know, that this vote was not taken, it has some context. Your last vote is 2 pages long. It says, it lays out procedurally what had happened, which was a request that you had made, and said that, you know, hey, look, we want to make sure that we're set up for.
I think if Mr. Kimball, if Peter Kimball was to take us to the housing court or to court over this, we could certainly pull that decision back up and
Okay,
present
so you
it.
don't have to do anything, but that was going to be my recommendation, is that you had a thorough decision. It referenced a bunch of things. I think you're fine. It is part of the record one way or the other, but that was going to be.
So we'll look forward to the email showing us the.
So I am going to get I'm actually going to do it in a letter. I'm going to get an engineer's letter that states, explains what the system is, and I will get a cost of what.
Because if you go back and you actually watch, and it's really quite long, the January 2017 meeting, it certainly is implied that there's nothing in Littleton. That's all been going over to Westford. And that's why we were in the June meeting asking, or July meeting, asking it for a letter clarifying if there was even piping over to this project. So clarification
Okay,
on what
fine,
was
so-
built would certainly be helpful in future conversations.
Okay.
And we'll send a letter to the selectmen asking to be included on the process of looking at what happens with this land.
Okay, thank you very much.
Thank you.
Good job, Lord. I think we're done.
Just kind of funny. So the last time,
Shall we officially close the meeting before we,
Yeah,
before we start doing that ad
Second.
libs?
yes.
All those in favor?
Aye.
So the last time I
Why don't you
had
off the
front row
council?
seats for the Bruins.